We are looking at how to pronounce this word in English, designating a person, typically a lawyer, appointed to act for another in business or legal matters. We are looking at how to pronounce attorney, attorney, attorney.
Paralegal.
Paralegal. Paralegal.
Warrant. Warrant. Arrest. Arrest.
Book. Book. Book.
Custody.
We are looking at how to pronounce this word in English, designating the temporary release of an accused person awaiting trial, sometimes on condition that a sum of money is lodged to guarantee their appearance in court. We are looking at how to pronounce bail, bail. Pretty straightforward. Bail.
In this video, we are going to look at how to pronounce plead in English. So before we say this word at full speed, let's break it into some syllables to make it easier for us to pronounce. So notice in the middle of this word we have an E sound. Plead. 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 So that's all for this video. If you enjoyed it and found the video helpful, please like it and also consider subscribing to our channel.
If you or someone you know is charged with a felony case, the first hearing that will be conducted in the Superior Court is called an arraignment. And you may be wondering what happens at that hearing. Hi, I'm Sean Hamp. I'm a trial attorney and criminal defense lawyer who practices law here in Mojave County, Arizona. At the arraignment, the judge will advise the defendant of their rights. The judge will advise them of their right to remain silent. The judge will advise them of their right to an attorney and their right to have a trial and be presumed innocent until proven guilty. The judge will advise the defendant of all these rights, and the judge will then tell the defendant what they're charged with in the indictment or the felony information. And after the charges are read, the judge will ask the defendant how they plead. Now, in most cases, a defendant would be advised by their attorney usually to go ahead and plead not guilty, because it's the state's burden to prove a defendant guilty beyond a reasonable doubt. After a defendant enters a not guilty plea, the judge will make a determination if that defendant can afford or not afford an attorney. If they can't afford an attorney, one will be appointed for them. The court will then set the matter in a felony case for what's called a case management hearing. And I've made other videos explaining what that is. The judge will also be apprised what the release conditions are. If there's a motion to redetermine release conditions, the court may address that motion at that time. If not, the court will probably affirm the release conditions in the Justice Court. Or, in a situation where a defendant has been summoned to come to court, the judge will set release conditions. And usually, if the defendant comes voluntarily to court, the judge will set them release on their own recognizance. So, if you or someone has an arraignment and a criminal case and you have any questions, please give my office a call. Let's find out if your case is something that we can help you with. Call my office at 928-753-6868 or visit my website at hamplaw.com.
So what is a pretrial motion? As the name implies, it's a motion that happens during the pretrial phase. A motion is simply a formal request that the judge order something. Examples of common motions in a criminal case include discovery motions, where you're trying to force the prosecutor to turn over additional evidence that they haven't given you yet. Or a special type of discovery motion called a pitches motion, which is where you're trying to get information from the law enforcement officer's personnel file to see if anybody's made complaints against them for dishonesty, racial bias, or excessive force. Another example of the pretrial motion is the motion to suppress evidence. This is where you seek to eliminate evidence that you believe was wrongfully obtained. This can be a very powerful motion, since if it's successful, that evidence doesn't get to come in at all, and that usually means that the entire case gets thrown out after the defense makes another motion, a motion to dismiss the case. The point of all of these different pretrial motions is to either gain information to strengthen the defendant's case or weaken the prosecution's, and to leverage either dismissal of the charges entirely or more favorable settlement terms. Pretrial motions are vitally important, since the entire shape of the case can change based on how those motions turn out. If you're facing criminal charges, we know you're going through a challenging time. On behalf of everyone here at the Kavanoky Law Firm, we hope this information helps you.
Conviction. Conviction.
Sentence. Sentence.